If you have an interest in the administration of an estate, whether you're an executor or a beneficiary, you may have questions about how the process works and what roles everyone plays. Specifically as it relates to an attorney, it's very helpful to get clarity on the attorney-client relationship, to define who are the individuals to whom the attorney owes a duty. So to frame this question in simple terms, who does the attorney represent? The beneficiaries or the executor? Now, this can vary by state, but where I practice in Pennsylvania, the attorney represents the executor, not the estate, and not the beneficiaries, at least not directly. What does that mean for you? So first, I'll speak directly to the executor, or sometimes we call this person the personal representative. As the person who's managing the estate, the executor has a fiduciary duty to handle the estate assets responsibly and in the best interest of the beneficiaries. Your attorney is there to support you, guiding you through the legal requirements and helping you make decisions that fulfill your duties. Essentially, the attorney is your legal advisor, ensuring that you administer the estate correctly. Next, I'll speak to the beneficiaries. Your interests are incredibly important, but it's key to understand that the attorney isn't representing you directly. Their role is to advise the executor, who's legally obligated to act in the best interest of all the beneficiaries. This structure helps maintain a clear line of responsibility and reduces the risks of conflicts of interest during the estate administration process. So why is this important? Knowing that the attorney is there to support the executor helps set clear expectations for everyone involved. This structure is designed to create efficiency, but the beneficiaries sometimes feel like they're left in the dark and without having direct legal guidance. So here are some things to know if you are a beneficiary. First, there are laws that require a certain level of transparency between the executor and the beneficiaries. And the attorney's job is to advise the executor on these laws and require strict adherence. So, for example, in Pennsylvania, the executor is required to provide legal notice of estate administration. And this notice is sent to anyone that's named in the will, and even some individuals who are not named in the will, depending on the relationship between these individuals and the decedent. If there is a will, a copy of it will be sent along with this legal notice. Now, there's an important caveat. Just because you receive this notice, it does not necessarily mean that you're entitled to receive any inheritance or that you ultimately will receive any inheritance. So, for example, if you are named in a will to receive a distribution, but the estate is insolvent, meaning that there are more debts than there are assets in the estate, you may end up without a distribution. Second, the executor is required to prepare and to submit to all of the beneficiaries a formal accounting of the estate. So this will show any assets that are coming into the estate and any payments that are going out of the estate. So there's another important caveat here. This formal accounting does not include certain assets that pass outside of the will, which are technically not estate assets. So for example, if you have a retirement account or an investment account that has beneficiaries named directly on the account, which pass directly to those named beneficiaries, these are not estate assets. And the executor does not have a duty to account for these assets or to provide any direct report of them to the beneficiaries. These legal requirements ensure a level of transparency in estate administration, and in my experience, for some beneficiaries, it's just not enough. Some beneficiaries want greater detail on exactly how the estate is being handled. They may want a level of detail that goes beyond the requirements that I mentioned earlier. Sometimes the executor may welcome the curiosity or the inquisitiveness of the beneficiaries, and sometimes they don't. And ultimately, it's not the attorney's job to yield to the demands of a beneficiary. As long as the executor has fulfilled the basic legal requirements, the attorney owes no further duty directly to the beneficiaries. In these situations where the beneficiaries want to know more about their legal rights with respect to the estate, and if the executor does not direct the attorney to accommodate certain requests, the beneficiary may find that their only alternative is to seek their own legal counsel. So let's drive this point home. Whether you are managing an estate or awaiting distributions from an estate, knowing that Pennsylvania courts view the attorney's role as representing the executor can help you better navigate the estate process. It ensures that everyone's role is clear, which is essential for smooth and fair estate administration. If you have any questions or need any further guidance on estate matters, it's always a good idea to consult with a qualified attorney who can provide personalized advice.